Secrecy. Secrecy refers to the provisions under the Patents Act where the controller, in the interest of the central government, is entitled to maintain an application in the unpublished mode. It remains unpublished and also pass some directions to keep it in the secret mode. Now, secrecy directions are issued under Section 35. When the invention has some relevance for defense purposes, the controller can give a direction to prohibit or to restrict the publication of information, and the notice of the application, give notice of the application and the direction to the central government. So he gives the direction to stop it, and the central government is informed. The central government, if it finds prejudicial to the defense of India, it can maintain the secrecy provision or it can revoke the directions. If no directions are given by the controller, then the central government may notify the controller to that effect. Now, the secrecy directions are periodically reviewed, and the directions may be reconsidered by the central government at intervals of 6 months, or if the applicant makes a request, it can be reconsidered. The directions can be revoked if there is nothing prejudicial to the defense of the nation, or they can be revoked if there is a foreign publication that happens by way of some activity other than what happens in India. So it's anyway published outside India. So that's a ground for the secrecy direction to be revoked. The result of reconsideration is that within 15 days from the receipt of the notice by the controller, there has to be some review, some action within that time period. Now, the consequences of Section 37 is that during the pendency of the secrecy directions, the controller can't refuse grant of a patent. He cannot refuse grant of a patent. The order passed by the controller is not appealable, and the application shall proceed to the stage of the grant, which means it can go do everything within the office. But if it is found to be in order, as long as there is a secrecy direction, it is not published. So the objective of a secrecy direction is not to stall prosecution. It is not to stall prosecution. It is to ensure that the information pertaining to that application does not come into the public domain. Because understand, every application would normally get published within an 18-month period, or if an applicant takes a request for publication, it is published even earlier. But when the controller feels that there is something that could affect the defense of the country, he could impose these secret provisions, or secrecy directions can be imposed when that information should, or there is a fear that that information, if it gets into the public domain, can be detrimental to the national interest. The consequences, the complete specification filed for application where a secrecy directive is given, the controller can, the government can by an order take over the invention. This is for government use under Section 100, 101 and 103. That could be one consequence. Or the patent, or because the delay affects the right of the applicant, there could be some solatium, some kind of a compensation given to the controller. So these are the two things when a secrecy direction is imposed and the government feels that that invention has to be put for government use. So these are two ways in which the government can remedy. There is no renewal fee that applicant is required to pay during the pendency of the secrecy provisions. The controller may extend the time during the secrecy provision. The controller may extend the time for anything that is required to be done under the Act. So there is no, this is a kind of a moratorium given by the controller. So if there is something that the applicant needs to do under the Act, and because of the secrecy provision he or she is not able to do it, then the controller will allow a moratorium over all the things, because it was due to the act of the office, patent office, that the thing could not be done. Okay, and the extension of time shall not be more than the period of the secrecy direction. So whatever extension the controller allows, moratorium the controller gives, should be within the period of the secrecy directions. Now, we have a provision where a person who is resident in India is required to make an application in India first. That's a requirement. Now, if the person needs to make an application outside India before he files an application in India, then he needs to take a permission. This is called the foreign filing license. The foreign filing license is mentioned in Form 25. The application form patent, if it is made in India, then 6 weeks before the foreign application, then no secrecy direction is required, because after 6 weeks the applicant can file his foreign application, and the foreign filing license will be granted only when the person wants to, or will be filed only when a person wants to first file the application abroad before he files it in India. Now, the controller can dispose such applications in 21 days, but there are exceptions in the case of defense, as we saw in secrecy directions, and applications pertaining to atomic energy. Now, what happens when an applicant contravenes the directions under 35 or the requirement under 39? 35 pertains to secrecy directions, 39 pertains to taking foreign permission for foreign filing. The application is deemed to be abandoned. The patent, if it is granted, is liable for revocation, and the directions issued under this chapter, which is chapter 7, are not appealable. There is no appeal against these directions, and there is also punishment up to 2 years and or fine, and the punishment is described in section 118 of the Act.